Hello and welcome to SentencingStats.com. This is Mark Allenbaugh, the Chief Strategy Officer for SentencingStats.com, the preeminent source for federal sentencing statistics and analyses that's available online. So today we are going to discuss or review the Paul Manafort sentencing. He obviously hasn't been convicted yet. But in case that he is, this presentation will review some likely guideline calculations, and based upon those calculations, what the commission sentencing data tells us, what an approximate sentence may be. What, in other words, what he could expect. So first off, for those of you who haven't seen it yet, Mr. Manafort's superseding indictment is available online. You could just Google it or go to the U.S. DOJ website. What you'll see is that they're essentially, for purposes of guidelines calculations that I'll discuss a little bit further in this presentation, three groups of offenses. One is, or one pool or one group are the bank fraud offenses that stem from allegations that Mr. Manafort lied to get some loans from financial institutions. The second group have to do with FBAR violations. Basically, on your personal tax return, there's a check the box if you have any foreign bank accounts, and the allegation is that Mr. Manafort had foreign bank accounts and neglected to check the box. And then finally, and related to the FBAR group of offenses, are just regular old tax fraud offenses. Mr. Manafort is alleged to have underreported or just not report several $1 million of income that he received from overseas work that he was doing on behalf of the Ukrainian government. So, but before we even get to that, the whole fact that Mr. Manafort is going to trial is really interesting. And it's interesting because most people don't go to trial, either in state or federal court in criminal cases. What we can see here, this is Table 11 from the most recent U.S. Sentencing Commission's source book of federal sentencing statistics. And here, as I've outlined here for fraud offenses, in 2017, according to the Commission, there were 6,029 convictions or sentences for various forms of fraud. 93.6 of those were convictions as a result of a plea, whereas 6.4% of those over here, far right corner or column, were the result of a trial. Now, as you can see, if you look at the overall conviction rates, plea versus trial, you can see that it's a little different for fraud. Slightly more people tend to fight the case or go to trial, so to speak, than in other types of cases. For example, drug trafficking, only 2.6% of defendants in those cases were convicted as a result of a trial versus 97.4% were convicted by way of plea. Variety of explanations could be could explain this disparity, if you will, or this difference. Most likely it has to do with the fact that many white-collar offenders, such as Mr. Manafort, have the means to hire private counsel and to vigorously litigate the case. But nonetheless, the conviction rates are quite high, even for those that do go to trial. As I just noted, it's about 93%. 93% of individuals who are convicted or sentenced are convicted as the result of a plea, whereas the other 6% are the result of a trial. But for those that do decide to go to trial, what if you roll the dice? What are the odds that you may wind up with an acquittal? Very low, as it turns out. This is the most recent data available from the Bureau of Justice Statistics, and this reviews the disposition of criminal cases in fiscal year 2013. And as we can see down here for fraud, there were more fraud cases back in fiscal year 2013 than in fiscal year 2017, but nonetheless, we could see the percentage here. 90.7% of all those 8,992 cases resulted in convictions, whereas just under 10% did not receive a conviction. But those that did go to trial, 367 went to trial and were convicted, whereas only 45 went to a jury trial, as what Mr. Manafort has done, and were acquitted or not convicted. And by the way the guidelines work, for those of you who may not be familiar, in the way federal sentencing law works, and it's rather controversial, is that even if you're acquitted, as Mr. Manafort, as we saw in a superseding indictment, he is charged with a total of 32 counts of various forms of fraud. Let's say he's acquitted on 31 of those counts. Well, if he's convicted on one, whatever that count is, all those other 31 counts still come in for sentencing. Acquitted conduct can and should be considered, according to some courts, although it's a little controversial and technical. Some courts say that courts can consider it but need not. Others say that they must. But be that as it may, they at least can. All courts are agreed that courts can, and most do, consider acquitted conduct for sentencing purposes. So Mr. Manafort needs to be acquitted on all 32 counts in order to not be sentenced for those counts. One conviction on one, everything comes in at sentencing. And that's per the U.S. Supreme Court's 1997 decision in United States versus Watts. So at any rate, the odds aren't very good for Mr. Manafort rolling the dice, going to trial, going to a jury trial. Again, 367 were convicted in fiscal year 2014, I should say, excuse me. 367 were convicted as a result of a jury trial. Only 45 escaped were acquitted. By the way, this is really interesting here, this large number. 779 cases were dismissed for the reasons are unknown. But if we take those out, the dismissed cases, and just look at straight cases that convictions versus pleas, this percentage of those convicted versus acquitted becomes even more onerous or worse. At any rate, the odds are not very good, so it's very questionable why what Mr. Manafort is trying to achieve here, and if he really understands his risk. Some have speculated that he's holding out for a pardon from President Trump. We shall see, as President Trump is fond of saying. So at any rate, Mr. Manafort has a very significant exposure. Based upon the 32 counts of conviction, his statutory maximum penalty is 305 years. And the way it works at the federal level is you take the counts of conviction and you add up the statutory maximum for each count. So, for example, here for tax fraud, he's charged with 5 counts of tax fraud. Each of those carries a 3-year mandatory statutory maximum. So 5 times 3 is 15 years, assuming he's convicted on all those counts. The FBAR group, as we can see here, there are 4 counts of the FBAR, 5-year stat max each for a total of 20 years. And then finally, he's looking at 30-year stat max for 9 counts of bank fraud. 9 counts, bank fraud times 30, gets you 270 years for a total of 305 years. Obviously, he's not going to do that. Amount of time or anywhere close to that. What controls, or really influences, no longer controls, in a technical sense, no longer controls, but very significantly influences sentencing at the federal level are the sentencing guidelines. And I'm going to discuss those in a second here. And what drives the sentencing guidelines are the loss amounts. And as I have already kind of previewed, there are 3 groups of offenses here: bank fraud, FBAR, and tax loss, or the tax fraud cases. So those break down into, and forgive me for getting very technical here, getting down into the weeds, but those break down into two loss amounts, or two different types of loss, if you will. One is the bank fraud loss. Looking at the superseding indictment, I have cited to the paragraphs in the superseding indictment here where I got these numbers. It appears that, at least as alleged in the superseding indictment, the total bank fraud is nearly $26 million. In other words, that the Mr. Manafort is alleged to have illegally obtained or misled banks to loan him nearly $26 million. Now, presumably, it's not clear if the banks lost that money, if he paid those back. From what I understand, he's paid some of those back, but even assuming that he paid all of them back, the way the guidelines operate, that is irrelevant. The fact that he fraudulently obtained these loans, all those loans amount are considered loss, or the term of art under the guidelines would be intended loss. So because he obtained them fraudulently. So again, you add up all these amounts and you get to nearly $26 million. Now for the unreported income, and the unreported income is the income that he did not report on his tax returns, which also includes necessarily the income that he received from foreign sources that were in foreign bank accounts that he neglected or is alleged to have neglected to check the box on. So these are kind of one and the same. The unreported income counts both for the FBAR group of offenses as well as the tax loss group, or the tax fraud group of offenses. And there, it's I'm going to calculate this as if it was tax loss. The way the tax loss works under the guidelines is you take up all the unreported income, and here the total unreported income as alleged in the superseding indictment, assuming I added this up correctly, is $31,614,000. Now under the guidelines, unreported income isn't the same as tax loss. The way the guidelines calculate it is you take the unreported income, whatever 28% of that unreported income is equivalent to the tax loss, and that's how you apply the guidelines there. So 28% of the $31 million is nearly $9 million in tax loss, $8.8 million. Obviously, this would be, should sentencing occur, should Mr. Manafort be convicted, this will be, both of these loss amounts I'm certain will be highly litigated in terms of what counts and what doesn't, and how the tax loss and the bank fraud loss should be calculated. But be that as it may, just on its face, and I should add one quick thing too, that the indictment doesn't control sentencing. The amounts that are alleged in there very often don't even need to be alleged. This is the superseding indictment that the special counsel has filed against Mr. Manafort is extremely detailed and contains a lot more information than you would see in a typical fraud or a tax fraud case. So be that as it may, whatever the amounts are in there, they do not control its sentencing. Additional amounts, and I certainly expect additional amounts to come in. Point being that the bank fraud loss amount of $26 million and the tax loss amount of nearly $9 million are very conservative estimates based off just the face of the superseding indictment. Almost always additional monies come in at sentencing, since they do not need to be alleged in the indictment. Okay, so let's go through the three groups. Let's start with bank fraud. If you're not a sentencing guidelines geek, you can skip forward in the presentation a few minutes and get to the part where I discuss the statistics, the sentencing statistics. But I'm just going to provide this quick analysis, or these analyses here, to justify how I came up with the final offense level. So here we're going to start off at a base offense level of 7 because the statutory maximum for bank fraud is greater than 20 years. Because he had more than $25 million in intended loss, as I explained, the loans will constitute intended loss. 22 levels are added to his offense level. He's certainly going to be hit with sophisticated means, which almost all large dollar white collar offenders are hit with. He received more than $1 million in gross receipts from a financial institution. He received several $1 million in gross receipts from a couple of financial institutions. So he's going to get a +2 for that. He's been charged with a conspiracy, several conspiracies. So assuming he's convicted of all of those, he will also get a leadership role. The highest he can get is a +4 for being a leader or organizer of a rather sophisticated fraud scheme that spanned international borders. And finally, he's also, I believe, he'll get hit with an obstruction of justice enhancement. And this has to do with his conduct while he was out on bail. Apparently, he was contacting some witnesses, or at least one witness, and the Special Counsel Mueller moved to revoke his bail, and the district court agreed. The district court in the District of Columbia agreed. It was interesting that for those of you who may not know, Mr. Manafort actually has 2 parallel criminal cases going on right now, one in the District of Columbia, both in federal court, one in D.C., and the other in Eastern District of Virginia, Alexandria. But he was out on bail for both of those, but D.C. decided to revoke his bail once the government had alleged that he was contacting a witness and potentially engaged in witness tampering. For those of you who haven't read the order granting the government's motion to rescind his bail, it's a good read. It's an interesting read, and that certainly is going to be cited by the probation office to give him an obstruction of justice enhancement. So he's going to get that, the 3C1.1. Obviously, he's not going to get an acceptance of responsibility, a -3 that most defendants get when they plead guilty. He's not going to get one because he didn't plead guilty. He's going to trial, or he has gone to trial. Today was the first day of trial. So his total offense level is 39 for this group, the bank fraud group, which is 262 to 327 months in criminal history category 1, which of course he's in criminal history 1. The second group is the FBAR violations, neglecting to check the box. Here, this is a very rarely utilized guideline. FBAR allegations FBAR convictions do not happen very often, mainly because criminal tax cases are very rare as it is, and FBAR violations are a subset of tax fraud cases. So I haven't done a count, but I would be surprised if there's even 100 of these a year. At any rate, the FBAR convictions, assuming he's convicted of the FBAR violations, are sentenced under 2S1.3. There you start with a 6, and then you take all the unreported funds, interestingly enough, and you treat the unreported funds as if they're loss. And you go back to the loss guidelines, and there basically any loss amount over $25 million, and here we said the loss amount for the unreported income, the unreported income, which is the FBAR and the tax loss, was $31 million. So anything over $25 million, I think between $25 and $35 million is a +22. So that's how I get the +22 right there. Okay, so we start off with a 28. It's questionable whether this pattern of unlawful activity would apply. Pattern of unlawful activity basically says if you neglect to check the box at least 2 times in 1 year, and the total amount that you've underreported is over $100,000, and here that $100,000 is easily met, then you get this +2. The question that I am not sure of is if he ever neglected to check the box twice in 1 year. Generally, you only check the box once a year on your tax returns. So this is going to, I think, really come down to what days he filed his tax returns. Hopefully for him, it was more than a year apart, but that may not be. Maybe he filed early one year and a little bit later another year. But that we'll have to see, and that is something that likely will be litigated. But on the way the superseding indictment is drafted, it seems to me, reading between the lines, that the government is expecting that this enhancement will apply as well. Again, he's also going to get a leadership role here, as well as an obstruction of justice enhancement. For the FBAR group, his total offense level is going to be 36, 188 to 235 months. Finally, we come to Group 3, the tax fraud. So there, the tax fraud, we start off at a 24. For tax fraud cases, you don't use the loss guidelines at 2B 1.1. You use the tax loss table that's actually at 2T 4.1. And there, as I noted before, his tax loss is just over 8 mil, or almost 9 mil. So there, as a result of that, he's going to be at a 24 per 2T 4.1, the tax loss table. He's also going to get a sophisticated means enhancement, and once again, just like with the other groups, leadership role and obstruction enhancement for a final offense level, for this group at least, I should say a subtotal of 32. Now, I'm not going to bore everybody with the very sophisticated grouping rules under the guidelines. Suffice it to say that the tax fraud cases and the FBAR cases, they're going to group together as one, mainly because it's the same harm and the same victim. The same harm is the unreported income, the tax loss, which resulted in tax loss, and the same victim, of course, is the United States government. So there, the groups 2 and 3 are going to mesh together into one group, and I'll just call it the FBAR group. I'm going to call it the FBAR group because the tax fraud is only a 32, whereas the FBAR group is 36. So tax is going to merge into the FBAR group, and that's going to lead us finally with two distinct groups: bank fraud and the FBAR violations, the FBAR group. So why don't those group? Because again, it's all unreported income, etc. Well, it isn't exactly. The bank fraud had to do with the proceeds. There were the loans that Manafort illegally obtained from the commercial banks, whereas the FBAR violations had to do with income that he derived overseas and did not report and didn't check the box. So those are two different harms, different victims. The FBAR violations, of course, the government; the bank fraud, of course, the commercial banks. So obviously he's going to want these to group. He's going to argue that these are going to group, but I don't think that will be successful. These two groups will not group. So you have two separate groups. One group at a 39, another group at a 36. So what happens then? Well, under the grouping rules, and this is the what I call the overall bank fraud group's highest, the way it works is when you have two groups that are within 4 or 5 levels of each other, you take whatever the highest group is, and then you add 2 levels. Again, forgive me for getting down into the weeds on grouping rules, but so that basically explains this extra 2 here, the bank fraud group plus the FBAR tax group. So this is the 39 here from the bank fraud group because it was the highest, and now we add in another 2 levels to account for that FBAR group. So that finally gets us to our final offense level of 41, which in a criminal history category 1 is 321 to 405 months, or 27 years to 33.8 years. So certainly a lot better than 305 years, but still obscenely high. Is he going to get anything like that? Well, that's where we come in. That's what Sentencing Stats does. It specializes in. Now that we have an offense level to look at, let's compare them to other people. And let's look at the commission data and see what other people that were sentenced under 2B 1.1 had a final offense level of 41 and criminal history category 1 received. And by the way, this is just the sentencing table. You can see here I've highlighted the 41. So he's near the top of the chart. He's almost to life. So he's up there very, very high. The guidelines treat his offense conduct, and again, it doesn't really matter what he's convicted of. As long as he's convicted of one of these offenses, everything else comes in. So the guidelines treat his offense conduct quite seriously. Okay, so I ran an analysis on our online tool where you can find at sentencingstats.com. You try it out for 30 days for free. And it's a very, very powerful tool, and appreciate any feedback that anybody has. At any rate, running this for Mr. Manafort, the first thing I did is I just looked at 2B 1.1, which is the fraud guideline, is the guideline that he's going to be sentenced under. I looked at it generally. Everybody that was in criminal history category 1, which are people that do not have any significant criminal history. Most of them have no criminal history or very, very minimal criminal history. But what do people get just generally under 2B 1.1? Well, here is what they get generally from 2006 through 2017. There were 18,542 individuals that were sentenced under 2B 1.1 in criminal history category 1. Their average sentence was only 19 months, and a median sentence was 3 months. I noted up here, I looked at a target sentence of a year and a day. The decimal point doesn't come through here just for ease of reading, but 12.03 months is a year and a day. For those who practice, you know the significance of a year and a day is that makes a defendant eligible for approximately 15% off of the sentence for good time conduct. So that's always the not always, but sometimes it's the target sentence that defendants seek, which would be a year and a day. So just for comparative purposes, let's see what a year and a day looks like. And a year and a day is in the 58.2nd percentile, which means that it's a little on the high side. 58.2% of all the 18,000 cases here received less than a year and a day as a sentence, and that you can see that here at the median, a median of only 3 months. That means half received less than 3 months, the other half received more than 3 months. And here you can see the statistics for the Fourth Circuit, which is what he's in, and the Eastern District of Virginia, which is actually the district he's going to be sentenced at. So we can see here there were 335 cases that have been sentenced between 2006 and 2017 under 2B 1.1 in criminal history 1 in that district. The average sentence was 25 months. The median was 12 months. The maximum sentence imposed was 720 months, which is quite significant. But as we can see here, most people, regardless of whether it's national, Fourth Circuit, or Eastern District of Virginia, receive a below guideline sentence, and that's what percent below FSG means. And then there's the average fine that those receive, that people receive. We throw the fines in there, but as many practitioners are already aware, most defendants, even the wealthy ones, do not receive a fine. Frankly, by the time even the wealthy ones have reached sentencing, all their assets have either been tapped out or are reserved for purposes of restitution, making a fine unnecessary or impossible, as the case may be. Okay, so that's, again, this is just looking at a 50,000 foot level on fraud sentences generally, and we can see that here's the median sentences nationwide. I did note that this median here of 3 months covers all 18,542 throughout the entire time period, 2006 through 2017. Here it was 6 months in 2017 last year. You could see how that median has changed, and it's gone up over the last several years, which is really interesting. It's an interesting find, and the reason why is because of the Booker case that occurred in 2005 that held the guidelines unconstitutional in terms of if they were imposed in a mandatory fashion. Since the Booker case, the guidelines are merely advisory. That has resulted in judges sentencing below the guideline range quite often, which has also resulted in many sentences for certain groups of offenders to decrease, except for white collar, which is really interesting. For fraud cases, the medians have bucked the trend, and offenders are getting higher sentences. Now, that doesn't mean that judges are sentencing more frequently in the guidelines range. They're actually sentencing offenders below the guideline range more frequently. So it's almost a paradox, and I could spend a whole other presentation explaining that paradox, but I'm not not for this presentation. But at any rate, the point simply of this this slide is to show you what, from a 50,000-foot level, what the sentences look like and the trend for fraud offenses. Quite low. Okay, so now let's drill down. Instead of the 50,000-foot level, let's get to the 50-foot level. And here, what I've done is I've focused only on those individuals that are similarly situated to Mr. Manafort, what I think his sentencing guideline calculation ultimately will be. So as I noted before, it's going to be at an offense level 41, criminal history 1, which gives us a guideline range of 324 to 405 months. That target sentence of a year and a day, well, that's now only in the 4.8th percentile, which actually is a surprising number to me. I'm surprised that it's that large, given the size of this guideline range. I would not have been surprised if nobody had received a year and a day or less at this high offense level. But nonetheless, so there is this very thin glimmer of hope that he might be able to argue he is similar to these individuals. But be that as it may, there are not that many people at this offense level. There are only 56 offenders between 2006 and 2017 sentenced under 2B 1.1 with an offense level 41 in criminal history category 1. So, and that's not very surprising, given that in order to get an offense level 41, you have to engage in a very, 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 very significant fraud. And there's not that many multi-million-dollar frauds. Obviously, most frauds are only a few $100,000 that are sentenced and prosecuted in federal court. At any rate, there were only 56 nationwide. The average sentence, very high, 166 months, and the median sentence, 168 months. Now, that should shock anybody, but where Mr. Manafort may see a little silver lining is it's nowhere close to the guidelines range. As a matter of fact, the maximum sentence ever imposed for those similarly situated to Mr. Manafort was 324 months. In other words, the bottom of the guidelines range. So the highest sentence anybody has ever received that's similarly situated to Mr. Manafort was 324 months. Now, that's just like an academic number, especially for Mr. Manafort, especially given his age, and I'll address that issue here in a few minutes. But nonetheless, what it does show, and this number speaks very explicitly about it, is the vast majority of those similarly situated to Mr. Manafort receive a sentence well below the guidelines range. Now, not a year and a day, still a significant sentence, but nowhere near this guidelines. Nowhere near the guidelines. Okay. And here this shows the median sentences From 2007, there was nobody in 2006, so that's why this chart starts at 2007. There's nobody in 2006 that had a final offense level of 41. Okay, so and we can see that now the median is 168. It's kind of gone up and down. This chart, frankly, isn't very informative from a statistical perspective. The reason being is there is only 56 cases. So one or two cases can make a huge difference, and that explains the volatility of this chart. So there's really nothing to read in here. I just threw it in for balance, but it wouldn't be something that I would read anything into or make any inferences from. Okay. Whereas this information, of course, I would. And here is a much better chart, and this was probably the most informative chart from where inferences can justifiably be made based upon the 56 cases that were identified. So this, again, is what we call a sentencing distribution. For those of you who trade stock, you may recognize this as the a bar graph that very often you see, or a box and whiskers is what we call it, graph that we see when trading stock, showing the high and low, et cetera, et cetera. Well, what this shows is, as noted up here, is the sentence distribution. This blue box here represents 50% of all the sentences. 50% of all the sentences that were sentenced under 2B 1.1 with a final offense level 41, criminal history category 1, were between 240 months and 66.3 months. So between 20 years and 5.5 years. That's where half the sentences go. And then you have some extreme ones all the way down. There were a couple that received no time. Most likely in those cases, it was because they were cooperating. We do have data on that. I just didn't analyze it. And then here, of course, is the maximum, as I indicated, of 324 months. So this is the range, which is quite a big range for such a small group of offenders, relatively speaking. But nonetheless, we can see where the bulk lies, the bulk of the similarly situated offenders. This line here in the middle, bisecting the blue box, is the median sentence of 168 months, and as indicated, the average is 165.5 months. So this Mr. Manafort and his attorneys could use at sentencing to not just tell the judge, look, give us something below 324 months. The judge may end up giving him 240 months. That's still at the high end. What this, by the way, the top of the box represents is the third quartile, which basically means that 240 months or 20 years is greater than 3/4 or 75% of all the 56 offenders in this category. 66.3, the bottom of the blue box, is the first quartile, or the 25th percentile, meaning it's greater than 25%. So 25, 75, first, third quartile, that's where we get our middle 50%. So this shows the court where the trend is overall, where sentences tend to be from down here, a low of almost 5.5 years to a high of 20 years. And this is a much more robust way of conveying to a court or to anybody the distribution of sentences rather than just using a single digit, such as the average or the median. This again gives the court or the probation office or the client a flavor of the spectrum of sentences that lie along that have been imposed. Again, not everybody gets the average. For example, not everybody gets a median in any sentencing scenario. There's always a distribution, and so it's good to see this particular distribution. So now, with that said, let's say that Mr. Manafort argues for, and I certainly would argue for, a sentence at the lower end of the box. Why is that? What's the principled reason other than give my guy a break, Your Honor? because this was arguably a very, very serious offense. Yes, he didn't kill anybody, but it went on for a long time. There's some shady things that were occurring as well too. Probably a lot we don't know now that will come out at sentencing. So I'm sure we have very little indication right now of all the aggravating factors. So he's going to have to really battle not just the high loss amount, but also additional aggravating factors stemming from his overseas conduct and what he was doing, and then also the lavish lifestyle that he was living in, the greed, et cetera, that the prosecutor is certain to parlay at sentencing. So what can he do to mitigate this? Your Honor, here's the stats, and here's basically the range where most people that are similarly situated to me. I mean, that's what the guidelines were designed to do, is to ensure those similarly situated receive similar sentences. And this is how you do it, through statistics. You can't do it through the guidelines anymore because they're advisory, and a lot of people vary to varying degrees below the guidelines. So that's why statistics are so important. So how do we get them down here? What would be the argument? Well, the biggest argument, the most immediate argument that comes to mind is his age. So I ran a life expectancy table. Obviously, there's many more sophisticated ways to do this using far better actuarial tables. But Social Security seems to be a pretty good bet, at least for a good guesstimate or a rough estimate. And I ran this today. He's 69.3 months. He was born April 1, kind of inauspicious. He was born on April Fool's Day, 1949. So he's now 69 years, 3 months old. So he has an additional life expectancy of 15.8 years, and he's expected to live to 85.2 years. He's expected to live 85.2 years, assuming he's not in custody. Because as it turns out, and it should shock nobody, long-term imprisonment is not good for your health. And don't take my word for it. Take Professor Evelyn Patterson's word for it. She published this article, the dose response of time served in prison on mortality using New York State prison data. She published this back in 2003 in the American Journal of Public Health. This got the attention actually of the Second Circuit. The Second Circuit cited this publication in United States versus Jenkins. You can just Google Evelyn Patterson and United States versus Jenkins to find the case out of the Second Circuit back in 2015, where the Second Circuit, citing this and some other data, reversed a within guidelines sentence. It was under the child pornography guidelines, but reversed a within guidelines sentence as substantively unreasonable. I won't explain the Jenkins opinion, but I encourage, for those of you who follow federal sentencing issues or practice, it's a good read. So the Second Circuit cited this, so it caught my attention. I went and pulled the full article and read it, and you can see this is just a picture of the article here, but this is the big takeaway. For each year served in prison, a person could expect to lose approximately 2 years of life. And I spoke to Professor Patterson about this to make sure that she means what she says here. She means what she wrote, and she does. That according to her data, that 2 years, 2 years of life expectancy is lost for every year of imprisonment. That changes once the inmate, by the way, is released. But that may not happen here with Mr. Manafort. In other words, once an inmate's released, then the life expectancy kind of climbs back up. The adverse effect of imprisonment climbs back up. But as we're going to see, may not be all that is meaningless for Mr. Manafort. So let's use Professor Patterson's finding here and see what effect that's going to have on Mr. Manafort. Well, here what I put together is, as I indicated, he's 69.3 years old right now, okay, 2018, and his life expectancy is 85.2. Well, this is perhaps overly simplistic, but I challenge anybody to come up with a better estimate using the data. but here is his age, and it just increases a year for every year of imprisonment. Okay, so at the end of uh, 10 years here, he'll be, or at 9 years, he'll be 78.3. It just shows an arbitrary number out there. Um, so this line, the life expectancy, this decreases 2 years, by 2 years for every year of imprisonment. So what this indicates is where it intersects just after, once he turns about 74, maybe around 75, that's it. In other words, his life expectancy is only about 5 years. So even a 10-year, certainly a sentence that is average for those that are similarly situated, as I indicated above. Let me get back to that slide here. So an average sentence is he will die in prison. It's an effective life sentence, which is what a lot of pundits have been making the obvious observation, but here I've done it in detail and backed it up with empirics, if you will. So certainly an average sentence and certainly a median sentence will result with him dying in prison. But even a sentence at the low end of the box, statistically speaking, also is going to result with him dying in prison. So the argument would be, in a case like this, that any sentence approaching 5 years is a de facto life sentence. So if you're going to give him 5 years, you might as well give him 50 because it's not going to make any difference. And I'm not accounting for, by the way, good time credit and things of that nature. So I'll just say giving him any sentence that will require him to actually serve 5 or more years in prison, that is going to be a de facto life sentence based upon the Social Security actuarial tables, along with Professor Patterson's study on the deleterious effects of life expectancy on long-term inmates. So there's one other thing, and I'll leave the presentation at this, is I would implore his counsel, and I'm sure they're already aware of these studies, that the Office of Inspector General put out not too long ago, one in 2016 here on the left and the other 2015, reviewing the medical staffing in the Bureau of Prisons and also the impact of the aging population in the Bureau of Prisons. The fastest growing population in the Bureau of Prisons, just like in our society writ large, are the elderly. And the elderly are very expensive for the BOP to manage. Generally speaking, not just with the elderly, but generally speaking, they're having a very difficult time, according to this report, just managing the health care of inmates, period. Is that they're understaffed, the staff that they have are overwhelmed, and they don't seem to have a really good plan on how to adequately staff and retain staff, because you can imagine being a medical staffer in a prison facility, high burnout rate. So they have not been able to retain professionals at the level that they should be. And this is according to the Office of Inspector General. You can Google these and find these online for free. Don't take my word for it, read it. But if you take my word for the summary, that's essentially what this study says, or this report, that the BOP is woefully understaffed and can't just handle the health care of inmates generally. And furthermore, the year before, which was actually revised a month before this came out, the Office of Inspector General also wrote a report indicating that BOP cannot handle elderly inmates, so it's like a double whammy. So the most obvious argument, the biggest mitigator that I see that Mr. Manafort has, is his age. But in sum, he's not going to get anywhere close to 305 years. He's not going to get anywhere close to even 325 months, which is the bottom of the guidelines range as I calculate it. He's looking more at just ballparking it. he's looking at a sentence in the 10-year range, around that. But even that sentence is going to be a de facto life sentence for him, given his age, and regardless of whether of his current health. Inmates do age quite quickly, even the healthy ones, once they go in. Prison is not a country club. There are no club feds. At any rate, this is Mark Allenbaugh for sentencingstats.com. Thank you very much for your time. I hope you enjoyed the presentation.